impersonal arguments very much, and this room was just renewed with all of its systems, so we're still learning it as well. So I apologize for that delay and technical difficulties. Good morning. Are we rolling? Good morning. This is the time set for oral argument in LUBA numbers 2025-047, 048, 049, Gould versus Deschutes County. I'm Board Chair Zamudio. Board members Basham and Wilson are also with us today. I'm not aware of any pending motions. Is there anything that the parties need to bring to our attention before we begin argument? Nothing from the parties. Okay. Please be aware that this oral argument is being recorded and live streamed. The board has allowed overlength oral argument in these appeals, and petitioners and intervener petitioner have a total of 40 minutes and may reserve up to 10 minutes for rebuttal. Have you decided how you'll share your time?
We're gonna do 30 minutes, 15 minutes each among the petitioner and intervener petitioner, and then 10 minutes on rebuttal, also split.
Okay,
Each.
thank you.
Going first.
Yes. Council, did you have anything to add?
Only with the podium here, does the board prefer that we stand, sit, or do you have a preference?
The recording will be better if you are speaking into the mic at the podium. So our preference would be that you approach the mic. If you are not comfortable with that, I think the mic is movable and you can take it to your table if you prefer. But I think for the record, it'll be clear if the parties approach the mic. And respondent and intervener respondent, you also have a total of 40 minutes to share. Have you decided how you'll share your time?
Yes, good morning. Stephanie Marshall, Senior Assistant Legal Counsel for Deschutes County. I will be starting with approximately 10 minutes and the remainder of the time will be taken by the applicant's representative.
Okay, and I will keep track of time up here, but I also ask that the parties keep track and are aware of your own time as it passes. And with that, whomever will start for petitioners, please, or interveners petitioners, please come up and state your name for the record and begin.
Get out it. May it please the board, Josh Newton appearing on behalf of the Confederated Tribes, the Warm Springs Reservation of Oregon, intervener petitioner in these appeals. With me at council table is my colleague, Ellen Grover, and we have some client representatives that I'd like to briefly introduce here today. First, we have the chairman of tribal council, Dennis White. We have in the middle, the general manager of the branch of natural resources for the tribe, Austin Smith, Jr. And we have a tribal councilman, Raymond Moody, here with us today.
Thank you and welcome.
My intent is to deliver remarks for up to 12 minutes unless interrupted and leave time for questions, but I certainly welcome questions. The tribe's appeal principally concerns remand issue number 3 as defined by the county. Before the remand hearing, Deschutes County issued 2 notices of public hearing describing the issues that LUBA had remanded. Both notices told every party that remand issue number 3 was, quote, whether the 2022 Fish and Wildlife Management Plan violates the treaty with the tribes of Middle Oregon dated June 25th, 1855. The parties prepared and argued that issue. The county's final decision, however, described its task differently. It stated that it was not asked to adjudicate the treaty. Those 2 descriptions are difficult to reconcile, and that inconsistency explains every error that followed, including, first, the county's refusal to reopen the record, and second, its failure to identify or apply the governing treaty standard. For those reasons, the decision should be remanded to the county for further proceedings. I intend to make 3 points here today. 1, the county never identified and applied the governing treaty standard. 2, deciding whether this approval complies with the treaty is not the same as adjudicating the treaty generally. And 3, once LUBA remanded, the evidentiary opportunity described by the Court of Appeals became part of the remand proceeding. Turning to the first issue, the county never identified and applied the governing treaty standard. Here, the chronology is straightforward. Court of Appeals held that the tribe preserved its argument that the county was required to consider the 1855 treaty in determining whether the plan satisfies the county standard. It therefore remanded to LUBA the issue to LUBA for reconsideration on the merits. LUBA then remanded to the county because the county was obligated to make findings addressing the preserved treaty issue. The county's notices of public hearing accurately reflected that remand. And as I noted, they informed every participant issue number 3 was whether the plan violates the treaty. That is the issue upon which the parties prepared argument and participated in the remand. The difficulty is not merely that the county described remand differently in its notices and its decision. The more fundamental problem is that the county never identified the governing treaty standard before concluding that the plan complied with the treaty. Instead, the county treated compliance with its local no net loss standard as sufficient to establish treaty compliance. It's not the analysis remand required. Secondly, determining whether the approval violates the treaty is not the same as adjudicating the treaty. The county's premise is mistaken. Tribes never argued that the county was required to define the full scope of treaty rights under federal law, nor did the Court of Appeals. As I've explained, the Court of Appeals held the treaty issue was preserved and LUBA remanded because the county was required to make findings addressing the issue. That required the county to determine whether this land use approval complies with applicable federal law, which here is the treaty. This is a familiar function of local governments in Oregon land use planning. Local governments routinely determine whether land use approvals comply with applicable federal law when those questions are properly presented. For example, local governments evaluate compliance with the Fair Housing Act, Americans with Disabilities Act, and the constitutional limitations where those authorities bear on the approval put for them. Those are compliance determinations. They're not abstract adjudications of federal law. The same is true here. The county was not asked to resolve every question that could arise under the 1855 treaty. It was asked to answer the question identified in its own notices of public hearing, whether the plan violates the treaty. This is a project-specific compliance determination. It's fundamentally different than a comprehensive interpretation of the treaty. But there's another problem. Even assuming the county understood that it was required to determine treaty compliance, it never identified the governing treaty standard. The tribe's position has consistently been that the treaty protects harvestable populations of treaty-protected fish. That requires analysis on a species-specific basis because the treaty protects individual fisheries, not to an aggregate concept of habitat. The county never addressed that standard. Instead, it concluded that overall finding of no net loss to habitat necessarily established treaty compliance. That substituted the county's local standard for the remanded treaty inquiry. Instead of answering the question, the county concluded that it had not been asked to adjudicate the treaty. It simply sidestepped the issue. Respectfully, that reframed remand into a question that no party, no prior tribunal had asked it to decide. In so doing, the county created a false choice that assumed either it must comprehensively adjudicate the 1855 treaty or need not consider the treaty at all. The remand required neither. It required the county to determine whether this approval complies with the treaty. Turning to the third point, once LUBA remanded, the court's remand instructions became operative. The applicant argues the court's discussion of additional evidence is dictum. Respectfully, the argument overlooks what actually occurred. Court assumed LUBA might remand the treaty issue to the county, and LUBA did exactly that. The condition identified by the court was therefore satisfied, and the court then explained what the remand proceeding would include. It would, quote, the court stated, remand, quote, will allow an opportunity for the tribe to present evidence of indigenous expertise and knowledge. The county refused that opportunity. Instead, it closed the record to the treaty issue. It then relied on the resulting absence of evidence to conclude that the tribe had failed to establish impacts to treaty-protected fish resources. And this is the procedural trap that the tribe has identified in its briefing. The decision maker cannot deny a party an opportunity to present evidence criticize the resulting absence of evidence, and then rely on that absence as the basis for rejecting the claim. The remaining errors all flow from the same mistaken premise. Once the county concluded it was not required to identify and approve the governing treaty standard, it first refused to conduct the remand proceeding contemplated by the Court of Appeals and LUBA. It denied the tribe the evidentiary opportunity that the remand contemplated and never decided the treaty issue. Instead, the county relied on a mistaken argument of waiver offered by the applicant, burden shifting, and its local no net loss analysis to avoid applying the governing treaty standard and deciding whether the plan violates the treaty. The county relied on future review to establish present compliance with the treaty. Those are separate assignments of error in the tribe's briefing, but they all stem from the same legal error. The county never identified and applied the treaty standard that LUBA remanded it to decide. At this point, I wanted to talk briefly about the issue of did the tribe raise that this is a treaty specific or a species specific standard? Tribe raised this in its intervener petitioner's brief, and it was never addressed by applicant or county in any of its briefing. We would direct the board to footnote 16 in the Court of Appeals decision because it succinctly summarizes the tribe's position and why the tribe is here. Why does this matter to the tribe? Court of Appeals said the tribe asserted before LUBA that its treaty protected fishery right is a resource that is at risk of potential loss or degradation as a result of Thornburg's project, which relies principally or primarily on groundwater withdrawals. Those withdrawals, the tribe asserts, will drain aquifers underlying the project that have connectivity to surface water flows to the continued survival at-risk fish species in the Deschutes Basin. The tribe doubts Thornburg's proposal to mitigate those negative impacts by buying or canceling existing water rights elsewhere in the basin will sufficiently ensure that there will be enough water for fish to survive in nearby streams, and to ensure water flow and temperature will be sufficient to allow harvestable numbers of at-risk species of fish to survive at the tribe's usual and accustomed fishing places during proper time of the year. The tribe asserts that the latter is necessary to sustain the fishery resource fulfillment of the tribe's treaty-protected right to that resource. There can be no doubt based on this record that the tribe has been focused at the species level in the 2023 proceedings, at LUBA in 2023, at the Court of Appeals, and again on remand. The waiver argument simply became a way for the county to avoid applying the appropriate treaty standard to ascertain whether the plan that it was being asked to approve violates the treaty. In conclusion, this appeal ultimately presents one straightforward question. Before the hearing, the county told every party that LUBA had remanded on the following issue, whether the plan violates the treaty. The county's decision, however, never identified the governing standard. It instead relied on record closure, waiver, burden shifting, and its own local standard to avoid deciding the issue under the proper standard. For those reasons, the tribe respectfully requests the board remand the decision with instructions to the county to reopen the record, to provide the evidentiary opportunity contemplated by the Court of Appeals and determine whether the plan violates the treaty under the proper treaty standard. Thank you. Happy to answer any questions.
Yes, thank you for your argument. My first question was your argument to the county and is your argument to us that the treaty right applies as an overarching federal law with its own independent standard, or is your argument that the county is required to apply the county no net loss standard in light of the treaty protected fishery resource?
Our position has been and continues to be that the county can't take action that violates the treaty.
Is the mechanism through that the treaty as its own overarching law, or is the mechanism the no net loss criterion?
Our view for this particular application would be, excuse me, getting over a cold, but our view for this particular application is the county has to evaluate its local land use standard in a manner that complies with the treaty. We understand that in 2010, the Court of Appeals determined, absent a treaty protected resource, the no net loss standard can be applied on a system-wide basis. The tribe's position is if it comes forward and says there are treaty protected fish resources at issue, they have to be evaluated on a species by species basis. So they
Through the no net loss standard, not
Through
as
the
an
no net
independent
loss standard.
criterion.
That's right.
Thank you. And other than the Court of Appeals decision, is there a legal basis requiring the county to reopen the record on remand, independent of the Court of Appeals decision?
Our view is that the county code that says that the county has to comply with the instructions of the Court of Appeals and LUBA would provide an independent basis for that. I think it's
Okay. And was there a sustained failure or delayed notice procedural error in the prior appeal at LUBA or the Court of Appeals?
Yeah, so the tribe took the position in the prior, before LUBA in 2023 and at the Court of Appeals, and this is uncontested, that it was not provided notice of the land use application and didn't become aware of the 2022 application until after the de novo appeals had been filed with the Board of County Commissioners. So the tribe was deprived of the opportunity to participate in the hearings officer process in the fall of 2022 and really had the opportunity or became involved late in the process due to lack of notice. That appeared to resonate with the Court of Appeals. Court of Appeals, I think, is saying the tribe ought to be able to introduce evidence that it alleges it was deprived of introducing during the prior proceedings.
But my question is, was there a procedural error articulated and sustained?
No.
So absent that, why is the Court of Appeals statement not dicta? If there's no underlying procedural right, why is what the Court of Appeals, what they assumed might happen, not dicta?
Yeah, I think that is a good question. And I think, importantly, I think the way to think about dicta, the way I think it's the appropriate way to think about dicta, is dicta generally applies when third parties are relying on a decision for judicial precedent, as opposed to instructions that the deciding tribunal is giving to the parties for future proceedings in that
What
case.
gave the Court of Appeals the authority to give that instruction, if not there being some underlying procedural right?
I don't know the answer to that.
So even if the county's correct that they, absent that language, they would not have had to reopen the record. It's your position that in your view, instructions, the county's view, dicta, that changes the game, and now they do have to open the record, even if they didn't have to before.
That's correct. And one thing to make clear is once the record wasn't reopened, the tribe accepted that for purposes of the remand and said, okay, this is the choice the county's made at applicant's urging. So we looked at the existing record and we asked, does the existing record meet the treaty standard? And in that circumstance, we identified gaps in the evidentiary record that shows that even on the information that the applicant had provided, they didn't consider all the treaty protected resources. They didn't look at this on a species by species basis. So the record itself is wanting. It cannot meet the treaty protected standard because at the time that record was created, the county and applicant were taking the position that the treaty issue had not been properly raised to the county.
So
Where
even,
was- go
I'll
ahead.
finish up on that. So even if the court did make an incorrect assumption that the record had to be reopened, is your position that the county should appeal that to to the Supreme Court if they didn't want to reopen the record?
Yes.
Okay, thanks.
And I don't want to eat into to Ms. Breger's time anymore.
Yeah, we would like to ask some follow-up questions, please. Or you could eat into your rebuttal time, or you could stop now and not answer further questions. It's up to you.
I can answer if it's okay with, yes.
Where was the species by species argument raised in the initial proceeding? So why would the applicant or the county have known that this was the framework that the tribes were asserting, so then to have made findings or presented evidence on that?
Yeah, in our footnote number 2 in our reply brief, we give the record citations for that. And specifically, we reference the tribe's petition for review before LUBA in 2023. And it's the original record 1065, and I can read that exactly. What we say, this is what I think the Court of Appeals looked at and nobody challenged. It's on page 37 of our petition for review. Yeah, the original or amended record 1065. We say the Board of County Commissioners cannot conclude as a matter of law that system-wide benefits, whatever that phrase may mean, satisfy the no net loss standard without expressly finding that the plan does not violate the treaty or an Oregon statute. The statute mandates that counties site destination resorts in a manner that's compatible with site and adjacent land uses, requiring, among other things, that important natural features, including habitat of threatened and endangered species, be retained. The habitat of the ESA listed species is thus not fungible and cannot be netted against habitat of non-ESA listed species. Similarly, habitat for fish species protected by the 1855 treaty cannot be sacrificed or traded for other benefits. Nothing in Gould 6, which is the 2010 decision, requires a contrary result because the Court of Appeals was not required to construe the local standard in the context of the 1855 treaty.
And you're quoting the petition for review in the prior appeal. Is there anywhere in the local record in the prior appeal where that is cited? And is that where you're pointing me to your footnote 2 cites to those places in the local record?
In our footnote 2, we cite to footnote 16 in the Court of Appeals decision. In our petition for review, we cite places in the original record where the tribe was focused on a species by species basis. In the information that we provided in support, so there were 3 letters that were submitted by Mr. Smith, and he talked about treaty protected fish resources, specifically mentioning steelhead and salmon. But the supplementary information that he provided, including the fish passage plan that was adopted as part of the Pelton project, goes through in excruciating detail the fish species that are to be reintroduced into the upper Deschutes Basin.
So your argument, just responsive, and I'm not trying to rush you, I just want to make sure we have enough time, is that holistic submission arguing about species by species should have put intervener and the county on fair notice that the tribes were asserting under the treaty requires a species by species analysis under the no net loss standard, notwithstanding the prior decision saying it's a habitat analysis.
That's right. And one final point, and then I will leave. We do believe that applicant in particular is conflating issue preservation with argument preservation. There's a duty to preserve the issue. That has been determined by the Court of Appeals for purposes of these proceedings. We preserve the treaty issue. The arguments about what the treaty requires, there's no statutory requirement that you come up with every argument. We've made the arguments on a species by species basis. It's the only fair reading of the record. And now the county, by its own determination, says it needs to determine, does this plan violate the treaty? How can it do that without determining what the correct standard is? Thank you.
Thank you. And you're at about 21 minutes right now, so just for your awareness and for your time management.
My name is Jennifer Brager. I represent petitioners Gould, Bishop, and Lipscomb. The county gagged the petitioners and the public in this remand proceeding. The problem started with the county deciding to accept applicants' extra record evidence via improper ex parte contact to determine the scope of the remand and what the notice of remand would include, which is well briefed by Bishop. The problems continued with the remand notice and the decision to keep the record closed on compliance and treaty matters. The public's voice was further restricted upon entry to the hearing when members of the public were met by staff, and this message on a giant poster with incorrect warnings that certain testimony would be prohibited. If Luba looks at the county's marked ER 1 through 2, staff member Will Groves actually used the word policing as a means to intimidate members of the public and restrict the due process opportunity of petitioners and the public alike. The restriction on public participation was made both as to the economics issue, which included new evidence that the general public had never had a chance to respond to, and the treaty issue, which the county failed to consider in the first go-around. Notwithstanding these procedural errors that unlawfully and unnecessarily chilled public participation, the county did not enforce its rules against the applicant's improper submittals, namely the new evidence that is the 2025 FWMP, which was submitted under expert signature. This submittal was not argument, but rather submitted as substantial evidence by the expert who had advised applicant on the FWMP since 2022. The 2025 FWMP stamped and signed by applicant's expert came in as part of the remand on a closed evidence record that the applicant requested. Between the Gould brief and Bishop brief, it is obvious that the submittal of the 2025 FWMP was improper. Nevertheless, if LUBA were to rule the submittal was valid, the 2025 FWMP represents the collapse of applicant's house of cards. In LUBA's 2024 final order, LUBA held that mere submittal of applications to OWRD was insufficient to demonstrate compliance with groundwater mitigation requirements. At petitioner's ER 8, the county decision acknowledges its understanding that ownership and cessation is not enough with OWRD application submittal, having quoted CTWS LUBA 64-65. Thus, the county understood that even with all three, including OWRD involvement, there was not substantial evidence without OWRD approval. The new 2025 FWMP is unresponsive to LUBA's order. Instead of requiring OWRD review and approval, the applicant now makes OWRD's involvement optional. This does not satisfy LUBA's remand order, which expressly held the ownership or assignment of a groundwater right and cessation of pumping a groundwater right alone could not meet the county's requirement that any negative impact on fish and wildlife resources will be completely mitigated, so there is no net loss or net degradation of the resource. That is the no net loss degradation standard.
I have a question about what you're calling the 2025 FWMP. What part of that is new evidence?
Well, the entire thing, if you look at the front page, there's multiple stamps. This is ER 39. It's stamped in 5/1/26. It's dated. The dates on the bottom. The last date is May 5th, 2025, as part of the remand proceeding.
What part of the substance of
Then
that
you
is
go to the
evidence?
section
I understand
D.
your,
Section D.
excuse me, I understand your
Sorry.
argument that the submission and the stamps by the professionals makes this something that is submitted for new evidence. But what part of the modifications is new evidence as opposed to, say, a modification of the decision itself, as in something like new findings? What makes it new evidence?
Because it's being presented for the first time, the compliance standard for groundwater is being provided for the first time to the public as a new means of meeting no net loss. And it's allowing the applicant to say that the FWMP is written means different things now. That cross-references for existing groundwater rights that would comply with this very compliance mechanism were already resolved, which they weren't. Bishop raised that below about the Dutch Pacific water right. LUBA nor the Court of Appeals made any distinction between future or current named groundwater rights. Both said the compliance mechanism doesn't meet the no net loss standard. And so we think that LUBA should be puzzled about why we're standing here again, arguing about the mere ownership and cessation of use.
I have, in my thinking, I'm separating it in two ways. So the first assignment of error, or one of your assignments of error, is saying the 2025, the modifications to the FWMP themselves are evidence for which petitioners were entitled to submit contrary evidence. Intervenor respondent's position is it's a modification of the compliance requirements. That itself is not evidence. What would be submitted in response to that was not able to be submitted? Counter evidence that those compliance mechanisms will not meet the no net loss standard? Is that?
Yes, there's all kinds of things we could
And were
submit
they-
about current water standards. And if you look at ER 65, which is their supposed compliance table. This is dated December 31st, 2024. It has a lot of information about what the applicant purports to be the status of its water rights. The public had no opportunity to respond to this evidence.
Okay, thank you. That answers my question.
Sure.
And then, I lost my train of thought for my follow-up question on that. Oh, the differentiation between the existing water rights and potential future water rights. I went back and looked at our decision and the Court of Appeals decision. It did seem to me that there was not a differentiation when we were looking at the initial compliance provision. My question is, on the facts in the record, are there any of those, what our parties are calling existing water rights, that have not been approved through an OWRD process that are now going to be considered as existing without any OWRD review? And if so, which ones and where is that identified? That was a compound question, so I can go back and break it into parts if you need to, but do you understand what I'm trying to get at?
Yeah, I do. And we have a table in the record. It's cited in our reply brief. And it summarizes the water rights as of the original record. There are some new citations in there that were meant for purposes of the economics argument, which was open to new evidence. You can ignore the new citations and still understand that no OWRD approval for these water rights is available. They're all pending or have been denied. So, or they're up on appeal. So there is no final analysis, no final determination for many of these named rights. That's why we challenged the Dutch Pacific
So the
right.
table that you're
I'll
referring
get you the
to,
number of the page on rebuttal.
okay, and is that appended to your petition or is that just in the record?
It's in the record and it's cited in the briefing through cross references. So
And just for clarity, is your position that none of those, what are called existing rights, have been through the OWRD process to a final conclusion, or are there some have and some have not?
I'm gonna look at it myself
Okay,
and I'll get back
Great,
to you.
thank you, appreciate that. Go ahead. And you're almost at 30 minutes, so if you were wanting to reserve 10 minutes for rebuttal, we are upon that time, but go
Yeah,
ahead.
I'll just say that the compliance issues notwithstanding, that we've well briefed the economics issue. You're really familiar with the substantial evidence test. I do want to say that there are grounds for reversal here. This is coming to you under DCC 2234-040B, the county's remand process. It has its own language about substantial modification that requires a new application. And it's clear that the applicant is so confused and its experts are so confused that it can't get it right. It's time to start again and look at these issues under current conditions. The tribe just told you they're concerned about their treaty. The public is concerned about wells, it's concerned about the environment, and it's concerned about sagebrush subdivisions and watering golf courses in the high desert in this drought condition. Thank you.
Other questions? Okay, thank you. You'll have intervener petitioner, petitioners, you'll have 9 minutes to share for your rebuttal. And we'll have the county, please state your name for the record. Thank you.
Okay.
Go
Good
ahead.
morning.
Good morning.
Stephanie Marshall, Senior Assistant Legal Counsel, representing Deschutes County in this matter. I'm going to limit my remarks to hopefully less than 10 minutes, merely addressing the procedural arguments. I've heard that there have been some questions of the intervener petitioner and petitioner on these matters. So in our brief, we address the claims of ex parte and bias, and also touched on the new evidence argument, and I'm going to be deferring to the applicant's attorney on that one, and then the Gould 2 argument on public participation. Briefly stated, oh shoot, it just vanished. Briefly stated, the claims of ex parte regarding a letter that was submitted by the applicant, that letter actually followed a letter that was submitted by the tribes. Pardon me, the letter was received on a Friday and was uploaded the following Tuesday in advance of the publicly noticed Board of Commissioners meeting. And it was included on the agenda as to what the matter was discussing. At that time, and we enclosed portions of the transcript, or quotes from the transcript in our brief, there was quite a bit of discussion as to A, the remanded matters, issues, and B, the short 120-day clock for making a decision on remand.
Was Petitioner Bishop permitted to comment at that meeting?
I believe that they were permitted to comment. The meeting opened, as it always does, with a 3-minute opportunity for anyone in the public to come up and make a public comment to the board. So I don't know if that answers your question.
Sort of, but I'll think of a follow-up question if I need one. I'm trying to figure out, I think the county's position is it's not ex parte, and even if it was disclosed, and so Petitioner Bishop had an opportunity to rebut it or to challenge it. And so I'm trying to sort out what's the county's position on when Petitioner Bishop had that opportunity. It sounds to me like what you're saying is they would have known about it and could have commented on it at the start of that work session. Is that what you're saying?
Yes, and it was a public meeting, not a work session. And the decision was made actually at the following meeting when they entered the order. I don't have the order number off the top of my head.
So just for the record, so we
Yeah.
can keep these dates clear.
Yes.
My understanding is that the email from the applicant was sent to the Board of Commissioners. The county posted that on April 15th, and then there was a meeting on April 16th. And the county's position is Bishop could have known about it to then make that comment at the outset of that meeting.
That's part of my answer. The
Okay.
other part is that the decision on reopening the record was made at a subsequent meeting. And moreover, throughout the entire process.
And what was the date of that subsequent meeting? And was that meeting open to
Yes,
public participation?
Every single meeting at which any of these procedural or substantive issues were discussed were open. There was not a single closed meeting or a secret meeting or anything that was taken, any action taken behind closed doors. And I don't know, I had my brief up, which.
If it's in the brief, I'm sure I
Okay,
can find
okay,
it
yeah,
in the
it's in the
brief.
brief.
So
Um,
the position is letter was disclosed. Petitioner Bishop had opportunities to challenge the contact or rebut the content of the contact.
Correct,
Okay.
correct. And my other point is that it was not substantive. It was really a question of like, what all do you want to take evidence on? There are 3 issues that have been remanded. And we've got these 1, 2, 3. And my understanding is the applicant said, we only need to present evidence on the economic issue. And the applicant has the burden of proof. And so their argument was, let's just limit it to that. And then the board has the discretion, and kind of jumping ahead a little bit to some of the questions the board asked earlier of intervener petitioner.
Just to
Um,
stay on the scope of the
sure.
remand issue, you're attempting to make a differentiation between the substance of the criteria and a procedural decision whether to reopen the record. Is there any legal authority for finding that ex parte contact does not include deliberation about a procedural posture that could have an impact on substantive rights of a party?
No.
Okay, thank you. Continue.
So the next point I was going to make was because the matter was not remanded to the county for any procedural issues, any Goal 2 issues, or any, you've not allowed enough public participation, it was entirely within the board's discretion as to whether to accept evidence on all, none, or 1 or 2 of the issues. And I've briefed that as well. Turning to bias, it's a very high standard to establish bias. Again, I think that the transcripts speak for themselves. There was robust discussion around, how long the application has been before the county, references to numbers of binders, et cetera. And at the end of the day, it was probably most compelling, the fact that there was only 120 days on remand. The rooms were filled with people that were there to participate, to witness. The allegation about chilling public participation, I I'm not here to testify, but, there was ample and robust public people in the room. And the evidence was limited. New evidence was limited to the economic issue. And then the last issue, I've pretty much covered both goal 2 and also the ex parte claims and bias. I don't believe that there's any bias that's been established under the high statements that have been made, like compelling people to vote a certain way. It was really kind of a statement of, we have so much, and shall we take more? I don't think we need to take more. And ultimately, the applicant has the burden of proof. And then the final note that I wanted to make on goal 2 is that I wanted to distinguish once more the Lenkeek decision, Lenkeek versus City of Talent. In that case, the applicant had modified the proposal and submitted new documentation in support of an amended application. We did not have that here, and I was just hearing the questions that that you all had for the appellant's attorney, and I will have Mr. Katsaroff, Mr. Katsaroff, on behalf of the applicant, will further delve into why the FWMP is not new evidence. So I'm not going to try to address that specifically. But if you have any other questions of me on procedure, that's what I'm covering today, and thank you very much.
No questions from the board. Thank you for your argument.
Thank you.
We'll turn to intervener respondent.
Good morning, board members. My name is Ken Katsaroff, and I'm attorney at Schwab, Williamson and Wyatt. I'm here on behalf of the intervener respondents. I'm going to try to say applicant, but I might say resort or Thornburg. A lot of stuff going on here. Before I kind of get into specifics on each assignment of error, I think it might be helpful to kind of go through an overview of what the Fish and Wildlife Plan is, how it works, how we got here. Because I think that there's some significant confusion on a couple of things. First, as this board, I think, is aware, the resort was essentially approved as part of its final master plan in 2008. Grab my water, sorry. As part of the final master plan approval, the resort had deferred compliance on this no net loss standard and adopted at that point in time the 2008 Fish and Wildlife Mitigation Plan. At least one board member here today was present at the same time as that. And what's interesting about that particular plan is it was substantially worse, quite frankly. There's no argument from any of the parties that the 2008 plan is any better than the 2022 plan, or what now has been deemed by petitioners as the 2025 plan. But what's interesting is that that plan authorized Thornburg to offset its pumping of up to 2,100 and plus acre feet of water through a series of measures that were mostly surface water. So COID, Central Oregon Irrigation District water, and a particular right from Big Falls. And so it provided surface water mitigation for groundwater impacts. It's not actually quite a good idea. And in fact, that plan was found to meet the no net loss standard, despite the fact that there was a quality degradation of the resource of 0.1 degree Celsius. Doesn't seem like a lot, but that kind of measurement actually can matter to fish. And so what we did as part of this process was listen to the public and say, you don't want golf courses, you don't want as much water use. And so we're going to reduce water use by about a third and cut a golf course and provide some other conservation measures which aren't material. And instead cut the water to a maximum authorization of 1,460 acre feet of water. So 30% reduction in water. We're also going to look at how we provide mitigation for that. And so that we provide cold seeps and springs water generally from groundwater sources. There's some that's not, but generally then provide cold water that get into the system. There's two really big points that have to be made to understand the plan. The first is that the Deschutes Basin is hydrologically connected. For the most part, there's a very robust aquifer. Millions of gallons of water each year is recharged. There is a drought. However, that has not impacted the aquifer and the groundwater. That has impacted somewhat surface flows and with particularity, irrigation district storage reservoirs. And why this is important is that what this record establishes, and this gets to a couple assignments of error later about why can't a junior water right holder just pick up this water? But what this record establishes is that OWRD has never, not once, never regulated off somebody who is using a groundwater right or a live flow right. So this idea that there's not enough water and that somebody else can just pick it up is simply not true. There's evidence directly from OWRD in this record that says that. But we have this hydrologically connected aquifer, which means everything that you pull out from groundwater later would have flown into either the Deschutes River or the Crooked River, generally north and or northeast of where the resort is. So that's the first thing. Everything's hydrologically connected. The second thing is that what this plan is designed to do is to mitigate Thornburg's impact of pulling water out of the ground, out of groundwater. Okay, and what that does is then Thornburg can't pull out any water at all, period. Thornburg can't pull a drop of water out of the aquifer unless there is an OWRD approval or authorization to do that. Meaning, unless OWRD approves something, we can't pull a single drop, and there is zero impact. Okay, so that's an overarching thing. If we don't use any water, there is zero impact, period. Okay, now let's get to how do we quantify our impacts? And so what we did is we used the two best models that exist, USGS's GS flow and EPA's Qual 2K. So one of those deals with water flow, quantity of habitat and water. The other deals with quality and temperature. And so we took, if you imagine a plane here and Thornburg sticks a giant straw on the ground and it pulls 1,460 acre feet of water out for decades, you create this zone of depression or cone of depression, okay? And that pulls water that otherwise potentially would have gone into the Deschutes River, the Crooked River. And we said, okay, now we know exactly what the impacts are if Thornburg is pumping its maximum allowable rate for decades. We know what the static impact is on habitat quantity and quality, no matter what. And then what we did is we looked at this suite of water rights that's found in section B of the FWMP. It's, I think, 6 different things. And they said, okay, if instead of using those rights in the places that they're currently pertinent to or appropriated from, or we cut off their straws, what impact does that have? We said, okay, well, if we cut this straw here, we'll have that water flows in there. If we cut this straw here, then it flows in there. And so what we found, what the experts found in dozens of technical reports that were analyzed during the last process and could have been analyzed by everybody else in this room or every petitioner, is it said, okay, if you take all of those measures, you meet the no net loss standard. You have no negative impact. In fact, what the biologist said, and I didn't, the right one, was essentially that in all reaches of the river, you have a net benefit. Sorry, said appear to be a net benefit for both fish quantity and quality at all sites evaluated and will result in no net loss for habitat quantity and quality. That's all reaches of the river. And so that's important. And that's all throughout the plan. There's several other places in this plan that say, and I can cite you right to them, ER 58. More importantly, the FWMP has accounted for the maximum amount of pumping that could occur of 1,460 acre feet and is providing mitigation that meets or exceeds the no net loss standard. There's multiple examples of that in this plan that, quite frankly, weren't appealed in the last go round. And yet we're still talking about it today. So the second part that's really interesting or really that needs to be understood, and it's been very much confused, is that suite of water rights represents about 1,300 acre feet of water, and yet it mitigates for 1,460 maximum pumping, okay? And the reason it does that is we've talked about OWRD having this overarching umbrella. In the Deschutes Basin, in order to use a drop of water, you have to mitigate on a one-to-one basis. If we want to pull a drop of water out of the ground, we have to put back a drop, okay? However, for no net loss fish mitigation, to show that there's no impact, we've done it with this suite of rights already, Okay, and that's what all of the science says. It's the plan says that was not upset on appeal. Okay. However, we have a problem as the resort. We have a slate of water rights or credits. That 1,300 acre feet that I was talking about also includes a TSAD mitigation project that's already completed. But in terms of what the resort owns, it's about 1,200, about just above 1,200. And assuming OWRD lets us use all of that water for mitigation, that still leaves a supply gap. Thornburg has a supply gap of about 243 at least acre feet of water. And that assumes we have full build out, which could take decades, and that we are pumping that full amount of water. It may never occur, but right now we have a supply gap. That's what the quote compliance measures deal with, is how do we qualify what rights we can use for supply. It has nothing to do with the no net loss fish mitigation standard, which means quite frankly, it's irrelevant. At worst, it's harmless error. So what did we do on remand? Because this is really important. What we recognized was that LUBA and the Court of Appeals was concerned with particularity of actually providing fish water. So what we did is we took the science, everything that was in the record, and that wasn't challenged and wasn't upset on appeal, and said, okay, you have this suite of water rights and the suite of measures that meets the no net loss fish mitigation standard. Well, how do we ensure that that water is actually being put in the stream or left in the aquifer? And how do we let the public know that? Said, okay, we are going to adopt a new table that requires a water right by water right, time by time, when we're taking it, where we're taking it, et cetera. And that has to be reported to the county and to ODF&W. That was not a requirement before. There was a reporting requirement, but it was loosey-goosey, okay? And so instead, we adopted a specific table that deals with it. That's not new evidence. That's a criteria that we say, okay, we're adding this to try to meet our no net loss burden, because people are concerned about whether or not we're leaving that water in the aquifer or not. This now specifically requires it. If you look at that table now, it says Thornburg's not pulling any water, and yet it's currently providing that 1,300 plus acre feet of water benefit. So it's currently mitigating no net loss mitigation, fish mitigation, despite the fact that it's not pulling any water. The second thing that we did, and that's essentially overlooked by petitioners. There's like, I think, one paragraph in their brief about the reporting requirements. The other thing that we did, which is substantial, in my opinion, is we adopted a new condition, condition 41. And what that condition says is if you change this mitigation, if you change it, we have to come back for a public process. That might not seem like it's a big deal. You're modifying the plan, you have to come back, but it is a huge deal. Because what this says is if OWRD doesn't allow us to use it for water mitigation, for supply mitigation, we can't change it. We can't just sell that water and try to get something new. That mitigation has to stay there, no matter what. Unless we want to go through this whole process again, which hopefully I'll be retired by then, if it ever happens. So I'm pretty young. At least I think. Anyway, so the point is that there's overarching parts of this plan where Thornburg can't pull a single drop of water without OWRD approval. However, it has already provided this suite of water rights that provides fish mitigation. And there's lots of language in the previous decision from LUBA that recognizes that there is a difference in between supply mitigation and fish mitigation. There's also language from LUBA, and I'm looking at page 50, slip opinion of the decision, and page 51, that says the county can, and in fact did, properly find substantial evidence that this is providing fish mitigation. And it didn't require an OWRD process. It instead looked at the evidence of pumping, evidence of use, all of those sorts of things that said, there is wet water here, you're providing the mitigation. Again, that was not challenged, these portions of the plan, and that finding was not upset on appeal. So it's the applicant's assertion that the no net loss standard has been met by providing this water, and that when we're talking about compliance, this is why I'm taking so much time on this, we are instead talking about the gap in supply, future water rights. And that's what the plain language of the plan says. And if you look at the Court of Appeals decision, they also recognize it. They also talk about how this was in fact a supply gap, that there's this 243 acre feet, and that this relates to future water rights that are to be used for appropriation. That's what the plan says, i.e. for use. Okay, so those compliance measures have, again, nothing to do with no net loss fish mitigation. They instead talk about if we need to fill that supply gap, what we do to get those. And so Luba asked us.
I have
Yep,
questions.
go
You're
ahead.
going really fast and
Yep,
covering
I am.
a
I'm
lot of
sorry. A
information.
lot to cover in
Uh,
a little bit of time.
I'm just going to reiterate the same
Yeah.
question that I had to
Mhm.
petitioners, and I'm looking now at what is section B
Mhm.
of the FWMP, which sets out a bunch of different certificates. I
Yep.
think there's like 7 of those, maybe more.
6 or 7, yeah.
Yeah, have those all been approved by OWRD processes?
We've included in our brief a table that discusses each one of these and where they are in that current process. Again, what's more important is that mitigation, that what the experts have said and what wasn't appealed is that water is there. And Luba made those findings, actually, that it would be reasonable for the county to determine based upon the pumping records, et cetera. Even ODF and W accepted.
Did the
those.
compliance requirements that were successfully challenged in the last appeal apply to those 7 certificates or only to the gap water?
Only the gap water. And that's what the plain language of the compliance provision has always said. Is that for new water rights, for additional water rights, okay?
So your argument to the county, and the county agreed with this, and your argument to us is it's already been decided that those 7 certificates are adequate, substantial evidence that that water will be used for mitigation, and that decision is already settled, so that's not an issue in this appeal.
Yes, but
Yes.
we have added additional measures, and that's the specific reporting requirement that goes on a water right by water right, update by update, which also includes us having to tell people what the status is of each of those rights and where it is in the process. But in the meantime, that water is still being placed in the aquifer. And even if OWRD never were to approve one of the actions, that water still, based upon this plan, has to stay there and we can't change it.
Okay, and I think I am being dense at this point, but I want to make sure that I understand. In your brief, you quote our prior decision where we say, given the record as a whole, a reasonable person could conclude that the water rights transactions proposed in the 2022 FWMP will result in no net loss to fish habitat based on quantities and quality of water modeled based on the listed water rights certificates. And that is on your page 8 of Pinnacle Intervenor Response Briefs in response to Gould's petition for review. And that's a citation to our prior decision at slip op 53.
Yeah.
Did that conclusion depend on those proposed water transfers being processed and approved by OWRD?
Absolutely not.
Was that argued in the prior appeal?
Whether or not that those have to be required.
Yeah, or that they couldn't be, that couldn't be accomplished? The OWRD approval was required, or that OWRD approval couldn't be
Yes, that was
accomplished?
argued before, because that Luba's finding in on that particular piece is related to Deschutes County, well, to our assertion in the previous proceeding that the county could just rely on water right certificates as having the proper amount of wet water. And we said, no, we did a lot more than that. We provided substantial evidence of pumping rights, et cetera, used photographs, yada, yada, yada. And the county then determined that that was enough to show that that water existed. Luba didn't make a ruling based upon whether or not water right certificates on their own were evidence of sufficiency for wet water, despite the fact that that statute says it's conclusive. What Luba did is it said, we're gonna look at the alternate findings, which said we looked at all of the substantial evidence and it would be reasonable to conclude. Does that make sense?
Yes, thank you.
Okay. Any more questions on this issue? Okay, so that kind of hits the compliance measures. Again, plain language of the plan has always been that that's for additional water rights, the gap, the supply. I'll say one last thing about this because it may or may not be relevant, and it kind of gets to the tribe's third assignment of error, which is if we look at additional supply rights under these provisions, the tribe asserts that those have to go through their own no net loss review procedure. Again, we've already shown what the total impact of Thornburg is. And so if we find another right that the resort wants to purchase and stop using in a location, that just adds more water, okay, into the whole system. And if instead they use that for mitigation and they're drawing down from the Thornburg's cone of depression, it's the same impact. And so supply rights it's a different thing. It doesn't impact no net loss. That has already been met. Additionally on that, just because I hit the tribe's third assignment of error there real quickly, that is contrary to the opinion of the Board of County Commissioners, which is it's a net. We're looking at net measures. And it wasn't an argument that was preserved or brought forth before. So I'll just say that. I'm gonna kind of go through the rest of Gould, I guess.
Can you just say that again, what you just said, so I make sure I understand what your
Sure.
point is?
There's two things. One, that argument wasn't raised before. And the second thing is if in fact we do you're talking about the tribe's third assignment of error. So that argument wasn't raised before. We submit that it's not preserved. And they want a water right by water right, no net loss analysis. This is a net issue, okay? We're looking at the whole plan, but factually, what the experts have shown is that we've already met the impact burden, okay? We know what Thornburg's impact is. And because of that, if you instead stop using a different water right to help mitigate for supply, so again, think about our big straw versus a different straw. We're cutting that straw off. That just leaves the water in that place, adds more to that system. Okay, so we're not actually adding any more impact. We know what the impact is from Thornburg. And what is conclusively decided in the last go round is that we only have to mitigate for Thornburg's impact. So the issue related to drought or whatnot that was at the very last second brought up by Ms. Bragger, it's a settled issue. We are not mitigating for other impacts. That is closed. Okay, sorry, I got off track.
I'm gonna stick with the tribes species by species argument.
Sure.
I understand, I think you have two responses to that. One was that was never raised in the initial proceeding, and under Beckett, issues that weren't raised and could have been raised in the initial proceeding, you can't then raise on remand. Tribes argue that's slicing between issue and argument too thinly, and that we should look at what a court of appeals has already determined and is binding on us, that the issue of the treaty rights and whether this application violates treaty rights or harms the treaty rights is an issue that was preserved. Why is the species by species analysis or standard requirement not just an argument under the treaty right? Why is that a new issue?
Well, it presents an entirely different standard than what was asserted before. Okay, so I have multiple answers to that. I'm going to start with the Court of Appeals because I think that's an important issue here. So what the Court of Appeals said, the tribe raised in their first assignment of error, is that LUBA erred in agreeing, quite frankly, with the county and us that the tribe's treaty right was not adequately preserved. They came in and they said, we have a treaty right. We argued that it was not properly preserved, that they had argued that you have to make this determination within the standard of meeting the treaty right. Court of Appeals said they did enough. You should have been on fair notice. Okay, that was their first assignment of error. And so LUBA, you erred because they raised it enough. The second assignment of error, and I'm getting to this on a long way because I think it matters. The second assignment of error was the county gave short shrift to indigenous knowledge, didn't consider it enough. And the Court of Appeals said, no, we're rejecting your argument. It's a substantial evidence issue. LUBA applied the substantial evidence test correctly. County did fine, good to go. So it agreed with them on the first assignment of error and preservation. It disagreed on the second assignment of error. And then at the bottom of that, in dicta, it then said, if the county, or sorry, if LUBA, not a predeterminate, LUBA could have made its decision there. If it's remanded, then they may have an opportunity to provide new evidence, okay? And so what then happened is really important, which is LUBA issued a new final opinion and order. And what that final opinion and order said was the county has to make, quote, on judicial review, the Court of Appeals agreed with the tribe that the issue was raised below. The issue was raised below with sufficient specificity so that the county was obligated to make findings addressing it, make findings addressing the treaty right. Didn't order us or the county to reopen the record or anything else. This was an appealable order. If the tribe thought that LUBA's remand was insufficient, that it instead needed to say, and the county must reopen the record or accept new evidence, which LUBA has done previously, then the tribe was bound to appeal this order. It didn't do so. Okay, so I think that's material because they've
I understand that argument. It doesn't really answer the question I'm asking. Is petitioner or the tribes are saying the issue of the treaty is preserved. Your argument or the county's conclusion that the species by species analysis was waived is cutting between issue and argument too thinly.
And what our answer to that is, and it's briefed, is that the issue of the treaty right was previously raised as an issue to, under its fishing clause, of a right to harvestable fish. And everything that was cited by the tribe previously was a habitat standard and direct acknowledgement and authoritative citing to the Court of Appeals decision on the no net loss standard, which said this is a net habitat standard and not a species by species analysis. That's what the tribe in every single submittal below said. Now, what the tribe is trying to argue now is that because it submitted its fish passage plan, that somehow put the county on notice that it had to do a species by species analysis, despite never actually articulating that, never saying that just because we put in other plan documents that, oh, by the way, the Court of Appeals rejected as things that we needed to consider as part of our mitigation, that somehow put you on notice of this new standard. And again, as we pointed out in our brief, and I went by submittal that was submitted by the tribes, was never raised. And in fact, what was authoritatively raised was the Court of Appeals decision on the 2008 FWMP that said this is just a net habitat standard. So when the tribe comes in and says it's a habitat standard, right to harvestable fish, which is a habitat standard, that's what they said. Now they come back and say you need a species by species analysis. That's completely changing what the applicable criteria is. And this happens all the time. I'm going to use the Red Side case as a really good example of that. The petitioners in that case came in and said, it's the same rule, but we're going to advance a brand new interpretation of that rule. That's what they're doing. They're saying we have a brand new interpretation of what our treaty right is, despite not providing any citation to it, to the treaty, to any other applicable law. And what we said is, hey, this is what you said before. And this is what the other federal case law says. So now we're expected to do a species by species analysis. That's not fair. You didn't say that before. It's a completely new standard. It's waived. Our second response to that, which is also in these briefs, is that they said at worst, you have to meet bare minimum ESA, Endangered Species Act protection. And so what we've provided in there also is a table that says, okay, to the extent you've provided any information as to what species you're even concerned with, we've met those. And we took those standards from the HCP, which they included in the record, and said, okay, these are the minimum flows that you're concerned with in the HCP. Oh, look, the FWMP more than meets that. And so we've kind of done
Did the county find that, or you're just pointing to evidence that the applicant submitted?
we're pointing to evidence that the applicant submitted in our brief. So basically it's, they're saying you have to meet that at a bare minimum, and we did meet it. And so what the county did is the county said, okay, you said this is a habitat issue, and we've already determined that there's a net benefit to all habitat quantity and quality. So how could we be degrading your right to harvestable fish, which is a habitat standard, if we've already determined that all reaches have a benefit? It doesn't make any logical sense. And so that's what the county did. The other part is that the tribe is arguing that we have to provide what the treaty standard is, but we don't even really know what it is, because they're saying it's a species by species analysis, but they haven't told us what species they care about or what reaches they care about. And what the county did make findings on and did include, as well as we did in our brief, is at least two cases that say that any party that's asserting a treaty right at a bare minimum has to tell you which species they're concerned with and how it actually impacts them, how it impacts the customary fishing areas. They didn't do that. They didn't even attempt to do it in the first proceeding. And despite the fact that the record was closed in this proceeding, they could still have said, and this is all throughout Luba's case law, they still could have said, we want to provide evidence as to how Chinook are going to be specifically impacted in this area. And the Board of County Commissioners could have said, okay, we'll reopen the record so that you can do that. They didn't do that. There was no claim that they could provide additional evidence. And quite frankly, there was no claim of prejudice. So we've well briefed this, but I'm hitting on it because you asked the question.
Yeah.
What's your next question? Because I only have a few more minutes.
I
I'd rather
think
get your questions than hear myself talk about random things.
Yes, I'll pose to you the question that I had for petitioner's attorney about their characterization of the modifications of the FWMP as evidence.
I mean, it's essentially a legal black box argument. You are required to address the compliance issues by Luba's remand. And yet if you submit anything to actually do that, that's new evidence and you can't actually get out of that box. It's not new evidence. We address the compliance provisions, period. It's new applicable criteria. It's new legal requirements that we have to meet. And the county determined that we met them based upon the record that was before it. Okay, it's not any change. I think that the premise that putting a new engineering stamp on the exact same document with like 4 words changed is new evidence is just kind of ridiculous. I mean, nothing else has changed. None of the substantive measures have changed. None of the impacts of the resort have changed. We haven't done anything else. We've just said, okay, you have to do more to meet compliance. That's not evidence.
And then the argument that the compliance table that is filled in contains new information on the status of, I think they're saying disputed information on the status of the OWRD approvals for those rights. Why is that not evidence?
Well, I think it could be, if I'm being honest. What is on this table, there is information about the current status, but the board didn't make any findings related to it. What the board said is we want this table as a format for you to fill out each year and provide to us and OWRD. And that will show that compliance is being met because you're showing what water is being kept in the stream and where. And so it was a format. Here's the table you must use. Before, the only requirement under condition 40 was that there was reporting. It didn't mean anything. And so now we're saying you have to make specific pieces in here which talk about each water right, where it is in the process, how much water is being left in, and the amount of water that Thornburg is using. So
So your response to that is because the county did not rely on that information, any procedural error in not allowing petitioners to submit responsive information is harmless error? Is that your argument?
that would be part of my argument. My second part is petitioners have argued for years now that none of these water rights are valid and that none of Thornburg's water rights are valid. And so, they've already responded, quite frankly. The point is that the plan says that if we take these measures, it meets the no net loss standard. It doesn't matter whether OWRD approves fish mitigation. The decision last time was also that OWRD approval may provide for fish mitigation and it may not. And what we said is, yeah, OWRD approval for fish mitigation itself doesn't matter. What matters is that the water is being kept in the stream and we're showing that it does. And that's what all of the expert opinion is. What matters for OWRD approval is supply, and that we can't use a single drop of water unless there's OWRD approval. And so OWRD approval is something that we rely on in order to get supply. And if we never get approval for any of the measures in here, which would allow Thornburg to use those rights for supply, it doesn't matter.
Questions from the board? Okay, I don't think we have any other questions.
I think I have 1 minute.
You do, go ahead.
I'm trying to decide if there's anything I want to try to hit for 1 minute. I guess I'll hit on a wide path of the economics issue. It's a substantial evidence issue. Bottom line is the reporting looked at the resort with the change, the modification of removing a golf course, and the county properly found it still provided substantial benefit. That's what it needed to do. I had one other thing I wanted to say.
Can you hit on the argument about the wage evidence not accounting for inflation, why that does not make the wage evidence that a reasonable person would not rely on to find an economic benefit?
We briefed and the county made substantial findings on all of that. I off the top of my head, I believe it did actually account for inflation, and the county made findings related to all of the economic issues, including wage.
I
But
think
as
your
a
brief
whole-
pointed to evidence that there was an increase in wages, but not adjusted for inflation.
I'm not sure. What I can say is that the standard as a whole is whether the modification, the changes made still makes a substantial benefit, and the county certainly made those findings.
And we're at
Okay?
time.
All
so
right.
Thank you for your argument
Get
today.
mine.
We will return to intervener petitioner and petitioner for rebuttal, and you'll have 9 minutes for your rebuttal.
Okay, record 2652.
Will you please restate your name for the record? and
Jennifer
who-
Brager,
Thank you.
petitioners.
Thank you. Go ahead.
The public may not comment on any topic. So record 2652 is the agenda for these work sessions that that the county said Bishop could participate in. But the very first page says the public may comment on any topic not on the current agenda. Record 2654 has action item 10, which is this item. Bishop had no opportunity to participate. The table that Chair Zamudio asked about is on record 1227 through 1229. There's a brief summary on reply, page 4 of Gould's reply. This speaks to the BFR right, which is right B, the tree farm temporary transfer, which is right D, and the Dutch Pacific, which is right E, which petitioners had always raised. None of those have been approved by OWRD for use on the site. The original record, page 749, was relied on by Luba and said, and this is expert Newton's response. It said, during such a review by the OWRD, the water right in question must be a certificated water right. Suitable evidence to prove use and availability will be questioned and investigated and a decision made regarding suitability for mitigation. This was again cited by Luba at 64 to 65. This means that OWRD review and approval is required. The cross petition before the Court of Appeals at record 797 to 798 and the Court of Appeals denying ownership and cessation at 387. The drought issue I raised at the closing of my opening was in relation to the economics argument. Again, no offsets were considered by JBREC. And when you go back to the table at 1227 to 1229, there's updated information about these water rights that mean there's going to be competition for scarce water supply. Again, not assessed by JBREC. And then I want to note for sure that applicant is again rewriting the FWMP in briefing, inserting OWRD before the word assignment. So if you can tell me what the FWMP means, then that would be great. But until then, this decision should be reversed so we can look at this issue holistically. And I'll leave the remainder of the time for the tribe.
I have one more question about the ex parte letter. Clearly, there's a dispute about the opportunity to rebut or respond. Your position as petitioner Bishop did not have an opportunity to rebut or respond prior to the Board of Commissioners' decision on the scope of the remand.
Yes, the decision was made.
May it please the board again, Josh Newton on behalf of the Confederated Tribes of Warm Springs. As a preliminary, I'd just like to object to applicant counsel's summary of the plan to the extent that I believe a portion of the summaries is not supported by the record. I just want to make a general objection. I want to talk a little bit about process, then I want to try to bring this down to why does the tribe care? Because if you believe applicant, everything is good. The plan actually results in a net benefit system-wide. So why does the tribe care? And I want to leave you with that. First of all, if I understood county council correctly, reopening the record is really at the request of the party that has the burden of proof. That's what I think I heard is why they reopened the record on the economic analysis, because applicant has the burden of proof. They felt they needed more information on remand, put into the record, and it's a contestable issue. And yet applicant and county are on now taking the position that the tribe actually has the burden of proof to show a treaty violation, but it doesn't give the tribe the same rights that it gave applicant in terms of reopening the record. And we disagree that the tribe has the burden of proof here. It's the applicant. But the county can't have it both ways. They can't reopen the record for applicant if applicant has the burden of proof and then tell the tribe it has the burden of proof, but it's not going to reopen the record because applicant says no. That seems that comes back to the procedural trap of what they haven't figured out. Applicants' counsel's argument, the majority of the argument as I was trying to get to my notes, I think was almost exclusively focused on compliance with the local county net loss standard. Applicants Council didn't grapple with the treaty standard. It chided the tribe a bit here and there for saying that we invented a new standard. We came up with a new standard for the first time on remand. But if you honestly put yourself in the position of the tribe who didn't have notice, who didn't get to participate in the hearing officer proceedings in 2022 and comes in at the de novo appeal and has less than 30 days to try to understand this fish and wildlife management plan, which I'm sure the board members would say that's a tall order. The tribe was telling the county, we don't have time. We have expertise and resources on staff. We can't marshal them in the time frame you've given us. We can't put forward our concerns about our treaty protected resources. That resonated with the Court of Appeals. That's what the Court of Appeals was getting at in its decision. That's when it looked at, if the remand is going to go back, it recognized that the tribe is not only a treaty right holder, it's a sovereign co-manager of the resource, the basin. There's no other party in this room that is that. The only other party that could claim that is ODFW. The tribe is not a project opponent. The tribe, its leaders, and we're charged with helping protect the tribal members' treaty protected rights. What does that mean and how can we put that into relief? Because we hear all this Ned and everything is great, but it's probably not. In this way, suppose for the sake of argument that this goes forward, Thornburg builds out and its groundwater pumping manifests a specific measurable impact to the lower Crooked River at a time of year when treaty protected fish are migrating through either up or down and cannot complete their life cycle. They're killed. Those fish are undeniably killed. So I suspect that Thornburg and his council will say, well, it really doesn't matter because we're actually improving fish habitat throughout the basin. But they don't distinguish among fish habitat. That fish habitat may be non-native brown trout fish species in the upper Deschutes. It may be fish habitat above Big Falls or Salmon Falls on the middle Deschutes River, which is a fish passage barrier for the treaty protected anadromy. So you're sacrificing at that point the treaty protected anadromy and saying, well, it's being offset with this fungible other habitat benefit. That can't be the outcome here. That puts a federal treaty right subordinate to a local ordinance. If the federal treaty right says you cannot harm those treaty protected fish in Lower Crooked River and you're harming them, you can't say, well, the invasive bass species or the perch in Lake Billy Chinook are really doing well, so all is good. Yet that's what the county standard allows. That's not what the treaty allows. And I suspect applicant knows that. And I also suspect that applicant knows that is going to be a difficult thing to grapple with, but that's the law. What the tribe can't understand is why the county is going along with this. The county framed the issue at the outset of the remand proceeding and said, we need to determine, does this violate the treaty? And then they shied away from it, undeniably.
What is the legal foundation for the standard that you proposed for the species by species analysis required by the no net loss standard?
The treaty itself.
Has that ever been interpreted to be applied on a species by species basis, or would we be interpreting it in the first instance that way?
Yeah, I think it's been interpreted on a species by species basis.
Are there citations to that in your brief on where that's happened?
Board Member Zamudi, I will say this, that in Oregon, the notion, there are only two treaty tribes in Oregon, Warm Springs and Umatilla. And to our understanding, this is the first time either tribe has put their treaty fishing rights at issue in a state land use proceeding. We think the closest that we can come to is the actual Court of Appeals decision in this case, which recognizes that we have a right to a harvestable population of fish. And that's actually conceded by the county.
Thank you. And we've reached 9 minutes. So I think that's a good place to end. Thank you for your argument today, and thank you for responding to the board's questions. We will take all of the briefing and the argument under consideration. The statutory due date for our decision in this appeal is July 13th. We'll ask the parties for an extension so that we can issue our decision by August 3rd. And I will just say, I think that's a very optimistic deadline to present, but we will ask the parties to agree to that. Is there any objection? Okay, thank you. And that will conclude our argument today.